Hey everybody, we're going to talk about standing and how that's important if you're fighting a foreclosure. The bank that's coming after you for the house may not actually own the note or mortgage, especially if they're just a servicer, and or if the note or mortgage was assigned improperly or robo-signed or was made after the closing date of the trust. There are many things can mess up standing for the bank. And here's a case that we can look at real quick. It's out of New York, U.S. National Association versus SAID. This is one win for the homeowner, basically. The bank came to court, tried to foreclose, and the homeowner said, "You don't own my house. Prove you own my house." This was a MERS mortgage, a typical MERS mortgage. And you can read the details online. I can leave the link to the actual case so you can read it better. But basically they're saying that the assignment was messed up, which happens in so many times. Anyway, the actual end of this says, here the plaintiff has failed to prove plaintiff has legal and equitable interest in the mortgage. The corrected assignment of mortgage provides in relevant part, and it again goes over the MERS stuff. Furthermore, the assignments that were prior to the assignment to plaintiff were invalid. The third assignment assigned the consolidated mortgage from MERS as nominee to the First United, granting ownership interest, and the ability to assign the consolidated mortgage is only First United. But basically, if you read through all this, you'll understand that they were playing a shell game using MERS. And the bottom line to that is, if one person doesn't have it, it can't send it to another person that has it. And so basically it says, conclusion, for the reasons set forth above, the plaintiff motion for summary judgment pursuant to the CPLR 3212 is denied in its entirety, and the defendant's cross motion for summary judgment dismissing plaintiff's complaint pursuant to 3212 is granted in its entirety. So that settles that, and the bank was sent back to the drawing board to try to figure out what to do next. Another case I want to show you real quick is an interesting case, also out of New York. It's called IndyMac Federal Bank versus Measles. I know some of y'all probably are familiar with this case. It's pretty famous. Basically, the bank tried to foreclose, and the judge's name is Arthur Shack. He's one of the good guys, good judges. There aren't too many of those out there. But basically, this case is interesting because it says, if plaintiff IndyMac Federal is a financial Count Dracula, then its counsel FS&C, which stands for Fine, Such and Crane, is its Renfield in the 1931 Bela Lugosi Dracula movie. Because basically the bank didn't exist when they filed this, and this was denied. The court grants relief to the defendant Measles. In this instant action, plaintiff IndyMac Fed lacks jurisdiction. It ceased to exist on March 19, 2009, almost 3 weeks before the instant action commenced April 9. If plaintiff IndyMac had jurisdiction and standing, it would be the legal equivalent of a vampire, the living dead. Further, the court is concerned that there are documents in this action which various individuals claim to be officers of the court of either the living dead IndyMac Fed or its deceased predecessor IndyMac FSB and the law firm of Fine, Such and Crane. And they commenced and prosecuted this meritless action, asserting false material statements on behalf of a client that ceased to exist 20 days prior. Okay, so basically this is a good case to use if the bank that's trying to sue you doesn't exist anymore, or if it was sold. Sometimes servicing rights are sold to another company, like I think with Countrywide it went to Bank of America. If your note wasn't also endorsed following the chain, like Countrywide should assign it to, or not sign it, but sign the note to Bank of America. And then Bank of America, if they own it, then they have it. And basically, if they try to foreclose and they didn't have it, because it goes back to the originating bank, if that bank is not in business or went out of business, and we all know Countrywide no longer exists, right? So if the chain of title on the assignments are not taking the mortgage to the correct party, you can have it dismissed for lack of jurisdiction, like Indy Mac did. So hope you will look into these cases. I will put the links to the cases in the description. Okay, talk soon, guys.